You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, welcome.
Good day.
So we're going to start off by taking a look at the Lehman Brothers case. Although it's been out of Chapter 11 for more than a year now, and it has made 3 distributions to creditors, it's still making law. I gather there's a dispute about the meaning of the words immediately preceding. What does this dispute mean in terms of dollars and cents for Lehman creditors?
Well, it means $64 million, but I just love what this is all about. Immediately preceding is pretty plain, simple English. It just shows to go you that when you get lawyers involved,
right,
simple English can take on multiple meanings.
Right, it's not that simple.
This is what happened. Lehman had an interest rate swap agreement with a federal home loan bank, I think, in Cincinnati. The swap agreement said that it would be terminated or defaulted immediately upon bankruptcy. Lehman filed Chapter 11 at 2 o'clock on a Monday morning. Mm-hmm. The dispute between these parties is over the words immediately preceding because you're supposed to value the swap immediately preceding the bankruptcy. Lehman takes the position that if you file at 2 o'clock in the morning before the market opens, immediately preceding means the preceding Friday when the markets were not roiled. On the other hand, the Home Loan Bank Board believes immediately preceding means that day, Monday, when the the markets were all confluent.
And a lot of money just hinges on this.
That's exactly right.
Simple principle.
If Lehman is right in its interpretation, it is an extra $64 million for Lehman creditors. There's one person I feel sorry for, that's the bankruptcy judge, trying to figure out what immediately proceeding means.
And Bill, I understand you're going to go out on a limb here and make a prediction about a case that you believe the United States Supreme Court will grant an appeal. What is it?
Absolutely right. A flat-footed conflict of circuits on the question of whether or not an inherited IRA is exempt property that creditors cannot reach if the person who inherits the IRA files bankruptcy. About a year ago, the Fifth Circuit Court of Appeals in New Orleans ruled that it is indeed exempt, just as are IRAs that a person creates for himself or herself. Lo and behold, this week, the Court of Appeals in Chicago, in an opinion written by one of my favorites, Frank Easterbrook, the chief judge out there, ruled exactly the dead opposite. He examined the Fifth Circuit decision, thought it was wrong, and concluded that an inherited IRA is something you've got to turn over to your creditors. So we have an absolutely flat-footed conflict of circuits, and that usually is a reason why the Supreme Court will, as they say, grant certiorari, or in plain language, agree to allow a further appeal. I'm guessing if the losing party, the bankrupt, tries to take an appeal, I think the Supreme Court will grant it, because this is just the kind of a bite-sized, individual Chapter 7 bankruptcy dispute that the Supreme Court loves. Yeah. They seem to me to like to stay away from these horribly complex Chapter 11 issues because the Supreme Court, like all other federal judges, is simply not comfortable with the complexities of Chapter 11.
That's a very interesting point. Bill, at the end of the day, should it go to the Supreme Court? How do you see the court coming down here? I know it's hard to ask, but
I have
so much money is at stake here.
The Fifth Circuit thought that it was a plain language issue, that the language of the statute gave you a plain meaning, but frankly, Judge Easterbrook took exactly the opposite conclusion. You know, when it comes to the Supreme Court and the justices, only Justice Breyer seems to be comfortable with bankruptcy. For the others, it's something they very seldom touch. Even Breyer, as he always says from the bench in practically every argument I've seen, always says how uncomfortable he is or how little he knows. But I think that's why he's good at bankruptcy, because he knows what he doesn't know and he works real hard on the opinions.
Right. All right, let's talk about the stock market. Bill, overseas shipholding is similar to American Airlines in that it's a bankrupt company where the stock is trading in the neighborhood of $4. Can you explain to us why the OSG stock is trading so high? I mean, they're bankrupt after all.
Well, frankly, no. I can't explain why it's so high. If I could, I would have written multiple stories already. It was easier with American Airlines because if you put some pen to paper, you could have figured out, and a few people did in 2012, that the holding company was going to be solvent and pay its creditors in full, and that's exactly what turned out. With OSG, it's a little different. This is an ocean-going freight carrier. In other words, it owns about 90 ocean-going vessels. That is a very sick industry, and it is a little unclear to me why a stock that you could have bought for $1 in February had risen to $4.50 by the middle of April. It well could be because OSG has some vessels that are called Jones Act vessels, which means they were built in the United States, they're crewed by American crews, and only these Jones Act vessels can be sailed between 2 U.S. ports. I'm thinking that there may be a lot of folks who believe that there is great value in the Jones Act vessels. In any event, a little something interesting happened. The company, OSG, had some rules for its executives which precluded them basically from selling stock. And they watched the stock zoom up to $4.50, but these people were sitting there, couldn't sell. So they changed their rules, allowing the executives to have a window of 5 days to sell. Guess what happened when the executives could sell?
This is grim stuff.
The stock dropped by about 17% in 1 day's trading, and it has stayed at that level. The bottom didn't fall out. It's still at $3.75, which is pretty darn high for a company in bankruptcy.
All right. And finally, Bill, I know we usually end up with the advance sheets, but this week we're going to end up with the stats section. You have a whole mess of data to dump on us. Let's have it.
The numbers are coming in pretty much the same as they have before, except in some ways worse for the bankruptcy community. The bond market is even hungrier for junk debt. Get this, in March, sales of junk debt was 27.5% more than in March a year ago. And a year ago, the market was gangbusters. But that's not all. In the first half of April, sales are up 37% over last year. So as we've said before, if the bond market is so eager for cruddy debt, then it's hard to imagine how a whole lot of companies are going to go bankrupt. And as a result of this, Moody's Investor Service is now projecting that the junk bond default rate by the end of the year is going to decline to 2.6% from 2.9% where it sits right now. If there is any good news I have for bankruptcy types, it's the following. And this comes from a study by Fitch, another rating company. They looked at 20 retailers that went into Chapter 11 and found that 11 of them, more than half, liquidated. They then compared that with 86 companies of all types and found that of those 86, 14 liquidated. But get this, Lee, 11, or in other words, almost all of them, were those retailers. Therefore, if you want to have a good old-fashioned bankruptcy liquidation, what you need is a retailer to go into the bankruptcy tank. And frankly, Lee, the way things are right now with consumer spending, where people are afraid to spend money, we may see more of that. And Fitch, in other words, is telling us that when a retailer goes bust, there is a better likelihood than not that that company is going to liquidate.
Right, we've seen that borne out with all the liquidating retailers we saw a couple years ago.
Right.
Bill, thanks for that. That's Bloomberg News, Bankruptcy Columnist Bill Rochelle. If you'd like to explore more about the cases and issues we just ran through, be sure to go read his column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.